Welcome back. You're watching HFO-TV.
Welcome back to HFO-TV. I'm Greg Frick, partner at HFO Investment Real Estate. Today joining us again, we have Charles Kovas from Warren Allen Attorneys. Thanks again for coming back. Today we're going to talk about some of the legislative changes, landlord-tenant law in the state of Oregon. Thanks again, and let's get right into it. It's been a busy year.
There's been a number of changes. Thanks again for having me, Greg. The changes aren't as bad as they could have been. Because for the first time in a long time, landlords are a bit more organized, and the landlords are starting to push back and lobby a little bit. There's everything from the Good Landlord PAC, which has recently been started, to the Rental Housing Alliance and multifamily, both taking a more active role in lobbying. And the changes this year, for the first time, actually, some of them benefit landlords.
Right. Which we haven't seen for a while.
We haven't. The big change that actually affects supply and demand is inclusionary zoning.
Yes.
And that was Senate Bill 1533. And it applies to developments where there are more than 20 units. There, the developers are going to be required to hold back no more than 20% of the units for low-income units. And
the low-income threshold is?
It's going to be 80%
of the median
family income in the local area. It also lifts a ban on construction excise taxes, allowing for the local government to adopt about 1% of the additional value for tax purposes. But ultimately, this change is designed to create more low-income units.
Now, is that only on the excise tax, only on new construction?
That's correct. It's only for new residential construction at this point.
Got it. Okay.
That change actually does affect the number of units. Some of the other changes don't affect the number of units, but they do affect the perception that tenants are being forced out of their homes with no place to go.
Right.
So the first change is a 90-day notice for rent increases. Now note, this has been in place in Portland since November.
Right, with the state of emergency, Portland did the change, but this is a statewide deal.
Statewide, correct.
Got it, okay.
And statewide now, you need to give 90 days notice before raising the rent. And it's not just the rent, it's any rent or associated housing costs.
Okay, so any utility rubs, any kind of things like that, you've got to give
all counts towards that total. And in Portland, it's any increase of more than 5%. Statewide, it's any increase, period. You need to give 90 days notice before it takes effect. Statewide, it's relatively interesting because it applies to month-to-month tenancies, but it doesn't necessarily apply to term leases.
Okay.
Now we have a little bit of lawyer speak for a minute. You generally can't change the rent on a term lease during the term.
Right.
And generally these term leases convert to month-to-month tenancies when they expire at the end of that 1 year.
Right.
So the savvy landlord is going to give a notice of termination and maybe a new rental agreement 90 days or more before that term lease ends, and let them know that if they continue month to month, it'll be subject to the new rent amount.
So so what you're saying is a savvy landlord wouldn't just allow the term lease to convert into a month-to-month. You would actually, in the lease, and start a new agreement.
That's right, because there's a bit of a gap in the statute.
Got it, okay.
It could be that once a few judges get a hold of this, they determine that, well, it clearly applied to the first year of a tenancy. But because it's written about month-to-month tenancies only, it's unclear about what happens when you're going from that year term into a year month-to-month rental agreement.
Because you could, in theory, have a judge say, we know he's month-to-month now,
that's right,
but the tenancy started as a term lease, he's going to be under the statutes of the term lease.
And this first year of the month-to-month rental agreement is what the statute was addressing.
Gotcha.
It wasn't addressing that prior year term. So landlord, you had the opportunity to raise the rent at the end of that first year when it converted, but now that you're into the first year of a month-to-month rental agreement, you can't. We don't think that was the intended purpose of the statute, but that is how it reads.
Gotcha, okay.
So that may have to be litigated. And if you don't want to be that landlord that's paying the legal fees for the rest of us, then the safe way to do it is to make sure that you plan for that 1-year term to end and convert into the month-to-month lease.
Right. Okay.
So, secondly, there have been a couple of technical changes. You'll remember there was a change last year about emergency exits.
Yes.
That sleeping units needed to have a secondary means of escape. Well, that led to a question. What about situations where you've got a 20-story building and there's a window, but there's no fire escape and the window doesn't open? What do you do? Well, the legislature addressed that change and they said the secondary means of egress needs to be to code when it was installed or when it was built.
So you're rolling back to code on the construction. Okay.
That's right. So if my 20-story building wasn't required to have a fire exit going up to the 20th story, the landlord is not required to build one now.
Gotcha. Okay.
So that
it's not
was
a retro coming back. That's okay.
That's correct. Ultimately, in fact, one of the classes I taught, one of my students brought it up the best and said, well, what we're really talking about here is the window big enough for a firefighter to be able to break it down with all of his or her gear on in the event of an emergency?
Right.
You're not going to find that definition in the code anywhere, but that's really what we're talking about.
Okay.
The last change in Oregon was upping a non-compliance fee for smoking to $250 instead of $50. It used to be that you could give a warning letter and then shortly after the warning letter, a second violation occurs, you could send a $50 fine.
Now it's $250.
Now it's $250.
Okay.
And the caveat is you have to wait until 48 hours after you served the warning letter to serve the fine.
Gotcha. Okay.
So this is the same thing that's currently in place for pet waste. Now it extends to smoking violations.
Oh, it does. Okay. So it'll go in line with what the pet waste one is, and this is again through the state.
Yes. And it's interesting, these fines were put in place as an incentive to the landlord to not terminate the tenant. Basically, how do we address behavior for relatively minor violations without terminating someone?
Right.
So the landlord doesn't have to serve a warning letter and then issue a fine. The landlord can just go right into termination. But if the landlord would rather correct the behavior and
get a little
keep
bit
the
more.
tenant, it provides an incentive to do so.
Got it. Okay. Now I did have a question, just to go back on the 90-day. Is there an amount of time when somebody comes in on a month-to-month lease before you can raise the rents? Do you have a limit as a month-to-month tenancy where you cannot raise the rents for a length of time?
That is now preempted by the state law.
Okay.
And so that's going to be the first year
Okay.
of the month-to-month tenancy. You can't raise the rent at all.
Right.
And that's why there's that gap in the statute of when the year term converts over to the month-to-month tenancy. Because now you have a situation where if you're looking at the year term first and then it converts, well, if you take those two sequentially, now you're dealing with a 2-year period. And that's not what the statute says.
Got it. So is there, just thinking on some of our owners and how they operate, is there any advantage now to go to a, let's say a year lease, as opposed to going to a month-to-month? It's almost like a month-to-month now. You're stuck on that rental rate for 12 months anyway.
My general preference when I speak to my clients is that they do a term lease.
Term lease.
And it has less to do with being stuck with them and what happens at the end and more to do with avoiding retaliation when a landlord wants to end the tenancy. Because when a tenancy just ends by its terms, it just ends by its terms.
Right.
But if it's month to month, the tenant knows it's about to end and the tenant can claim repairs.
Right.
Tenant, if they're particularly devious, could create repair issues for landlord and then prevent the landlord from serving a notice of termination because all of a sudden that notice is presumptively retaliatory when it comes within 6 months of the tenant making a complaint about the premises. So if you have a term lease that ends by its terms on a certain date and does not convert to month, then it's just over.
Right. But the big key for you on your clients, like you said, is turning that into giving that notice 90 days prior to that term lease expiring, acknowledging that the term lease is over, you're going to go to a new rental agreement that's month to month.
That's right.
And we're starting a whole new
And then it's 2 separate rental agreements, and the statutory problem doesn't really come into play.
Gotcha. Okay. And then in terms of, I know another thing that's been talked about is the no cause notices.
Yep.
A lot of advocacy groups want to eliminate those completely. I think that was on the table down in Salem. Is that, kind of what's your thought on those?
Well, there's been some talk that there's no such thing as a no cause notice. The landlord always has a reason.
Right.
And that may be true in some circumstances, but it could be a perfectly legitimate good faith reason. For example, what if you have a tenant who is dealing drugs, right, and you have no witnesses who feel safe coming forward? In that situation, the landlord should be able to terminate a tenancy because the landlord's not required to be a landlord forever. Just because you're a landlord does not make you an indentured servant to your tenant.
Right.
You could have other uses for that property. It could be that you want to sell that property because that's your retirement. You want to get out of the landlord business. It could be that that in fact was your own parents' home and you now want to make it available for your own child.
Right.
There could be a lot of reasons having nothing to do with this tenant why you now have another use for that property. So I think there is a purpose for the no cause notice. And I think that saying that there's no reason for it pretends that every tenant is doing it for good faith reasons,
right,
much like my clients are.
Right.
Not to say there are no slum landlords, there are.
Oh yeah.
But to say that every landlord's a bad landlord is the same thing as saying every tenant's a perfect tenant. People are people.
Exactly.
And it's noteworthy that in the state of Oregon, our legislature did not agree with the city of Portland, and they did not decide to extend no cause notices to 90 days. Outside the city of Portland, we're still looking at 30 days if a tenant who's been there for less than a year, and 60 days if you're a tenant who's been there for more than a year. It's only in the city of Portland where it's now 90 days for a no cause notice regardless of how long they've been there.
Right, and that's just within the city starting now.
That's right.
Right.
So
Okay.
again, I think it's important to note that the legislature didn't agree with the scope of the emergency that our city leaders here in Portland believed, right, that they needed to address.
Do you think the city will come back more towards the statewide law, where it's try to get more step in step with the state, so you don't have landlords kind of bouncing back and forth between what city they're in?
I would hope so. There is still a lawsuit pending about the local Portland rules, because the Landlord-Tenant Act provides that there can't be any local rent controls or local ordinances. Generally, state law supersedes and preempts local ordinances. That's something that's going to have to be decided by the judges in Multnomah County, because right now it is still pending. My hope is that they would move back into concert with overall state law, because as some of the changes we talked about, specifically the inclusionary zoning change, well, that does affect the number of affordable housing units. These changes don't, and in my personal opinion, may lead to unintended consequences, such as rents going up higher, which would lead to fewer
units being built. Exactly. Now, we've discussed that. If you don't address the supply side and you're making long-term changes for a short-term, that had a short-term consequence, instead of looking at the long-term unintended, consequences of making some of these changes, may go completely against what you're trying to protect or achieve, a building of affordable housing.
That's right.
And as we talk about with rent control, you put look at areas that have rent control. The issue is not, it's an issue of more unaffordable housing, because there's no motivation to build more housing. And if we don't address the more housing with people wanting to come to live here, you're going to have immigration. I mean, the only way you can stop that.
Particularly in an environment where rents have gone up, I think the statistic was 11%, and housing prices in the last year in the metro area have gone up a similar amount. So what's the incentive for the landlord to hold on to the property, manage that property, pay money on that property on a monthly basis, when they can just sit for a year, prices go up 10%, and they can turn the house and sell it?
Right.
Well, that not only decreases the availability of affordable housing, but it decreases the availability of housing, period.
Exactly. So that'll be interesting to see. So now again, in Oregon, the legislation is coming back in 17.
Yes, the temporary session or the short session has ended with these changes, and they'll come back next year. We know that some of these fee issues are going to be on the table. Again. And unfortunately, there are also some talks about rent control being added to the legislature's agenda. We also know that one of the hot button issues that didn't pass in the special session was providing moving money for tenants.
Right, relocation money, yes.
That's right, up to 1 month's rent when their tenancy ends. Those things didn't pass, but if landlords aren't engaged, there could be some pretty dramatic changes affecting landlords' bottom lines coming out of Salem next year.
And where, if landlords want to get information, where would be a good spot for them to kind of find, where these changes are?
Well, generally, Multifamily Northwest and the Rental Housing Alliance both keep pretty up-to-date websites. And landlords can find their changes either on their websites or by contacting those organizations directly. While the changes that haven't happened yet aren't on our website, my firm does maintain a website, OregonLandlordLaw.com, which is up to date with the steps that the landlord should take in order to be in compliance.
Right. Which again, for being a landlord, especially ones that do self-management, is a very big key. In terms of making sure your rental agreements are in compliance, your notifications are in compliance, and things like that, especially in this market.
You hear it all the time, but landlords generally have to pay the freight for their cases going forward. The statutes are set up to protect the most vulnerable. So generally, the winning party gets a judgment for attorney's fees. If the landlord gets a judgment, well, odds are the tenant may not be able to pay that. If the tenant gets a judgment, the landlord is going to be able to pay it. And the landlord's attorneys and the tenant's attorneys know about that dynamic. So there are tenant's attorneys who make their living on landlords who make mistakes. So the best way the landlords can protect themselves is by staying involved, going to classes, and by joining either the RHA or Multifamily Northwest and making sure their forms are up to date and making sure they're in touch with other landlords and they find out what's happening out there so that they're not the test case.
Nobody wants to be the test case.
Change in the law.
No, nobody's. Well, thank you again for coming. It was very informative. And again, for landlords out there, I think that was the biggest piece of advice is you've got to keep informed. There's a lot of changes that have happened in the last year, and I think there'll be more next year. And again, if you're not informed, you're opening yourself up to liability. And again, you don't want to be the test case. Nobody wants to be the test case in this. So again, thanks again for coming, and we'll see you again next time on HFO-TV. Thanks. That was great. Thank you.
Our entire office specializes in multifamily real estate, making HFO the largest multifamily brokerage in the Pacific Northwest. Your success is our passion. Build your legacy with HFO. Call 503-241-5541 or visit our website at hfore.com for more information.